Alternative dispute resolution is often presented as a streamlined alternative to the rigid procedures of a traditional courtroom. Within the context of Florida condominium law, that perception of flexibility often masks a set of strict requirements that can disqualify a defense before it even begins. The process begins with this specific document, a standard order requiring answer issued by the Department of Business and Professional Regulation. This particular case involves a 2026 election dispute filed by unit owner Leslie Morse against the Imperial House Condominium Association. Beneath the case information, these three underlined words initiate a mandatory procedural timeline for the association. This document establishes a specialized administrative framework where even minor deviations from the rules lead to immediate default judgments. For a condominium association, the arrival of this order creates an immediate risk that requires a precise technical response. Standard civil litigation tactics, which often rely on broad responses and extended timelines, are largely ineffective under these rules. By deconstructing the text of this order, we can identify the specific requirements that function as procedural hurdles for the respondent. We will analyze form restrictions, immediate evidentiary requirements, and representational rules favoring the petitioner. A successful defense requires analyzing this order as a rigid logic matrix rather than a standard piece of legal correspondence. The numbered instructions on page 2 of the order outline the specific operational constraints the association must follow. Paragraph 1 establishes a strict 20-day window for the association to file its answer, measured from the moment the order is received. The order mandates specific state form, DBPR Form ARB 6000-003. Filing custom legal pleadings is a procedural failure. Paragraph 2 further restricts the defense. A general denial is insufficient, and any facts not specifically denied are treated as admitted. While general denials are common in civil court, they are prohibited here, forcing immediate commitment to detailed facts. Paragraph 3 adds an evidentiary requirement. Alternate defenses must include supporting documentation attached directly to the answer. Defenses that are not raised in this initial filing are considered permanently waived and cannot be introduced later in the proceeding. This structure forces the association to produce evidence and finalize its legal strategy within the first 20 days, a task usually reserved for the discovery phase of a lawsuit. Paragraph 4 limits the scope of the association's response by restricting the types of claims that can be raised. Including a counterclaim or a new claim against the petitioner within the answer is expressly forbidden. To raise its own claims, the association must file a completely separate petition using a different form and paying an additional filing fee. The service list reveals a significant difference in requirements for the two parties. Petitioner Leslie Morse is permitted to proceed pro se, meaning they can navigate this entire arbitration process without an attorney. Paragraph 6 establishes a different standard for the condominium association. The order states that the association must be represented by a licensed Florida attorney. This rule prevents board members or property managers from signing or filing the required forms on behalf of the association. This requirement ensures the association incurs immediate legal costs, creating a financial burden that the pro se petitioner does not share. The order concludes by detailing the consequences of failure. Any answer that fails to comply with state rules or these specific instructions may be stricken by the arbitrator, leading to an immediate order of default against the association. A default judgment means the arbitrator accepts all facts alleged in the petitioner's claim as true, ending the association's ability to defend the case. Footnote 2 details further restrictions on communication with the arbitrator that can lead to similar outcomes. All communications must be sent to all parties simultaneously. Emails that do not copy the opposing party are disregarded, which can result in missed deadlines or ignored evidence. These rules function as a series of precision requirements, where a single mistake leads to an automatic loss. The rigid structure of the order is designed to influence the behavior of the parties through specific financial consequences. On page 4, the order cites the Florida statute that governs the financial outcome of the case. Under Section 718.1255, the losing party is legally required to pay the costs and attorney's fees of the prevailing party. For the association, this creates a situation where losing the case means paying for both its own required legal counsel and the petitioner's expenses. When the order arrives, the association must choose between two paths: litigation or settlement. The high risk of a procedural default, combined with mandatory fee shifting, makes litigation a high-cost gamble. The framework achieves its stated goal of encouraging settlement by making the alternative of a contested case, with its rigid requirements and mandatory fees, prohibitively expensive for the association. Ultimately, the DBPR framework operates as a highly engineered environment designed to resolve disputes quickly through strict compliance. This environment is sustained by three elements: front-loaded evidentiary requirements, representational rules mandating attorney costs, and mandatory fee shifting. Board members and practitioners must approach this arbitration process with the same technical rigor required in a high-stakes court case. Maintaining a defense requires literal adherence to the DBPR's specific forms and timelines. Success in Florida condominium arbitration begins with treating this initial order as a precision-timed procedural requirement that determines the outcome of the dispute from day one.